We're here today to talk about the Affordable Care Act and specifically the employer mandate. But I thought before we get too far into just discussing the employer mandate, it would be good to just look a little bit back as to where we've been with the Affordable Care Act and give you all sort of just a general overview of the Affordable Care Act so that you can maybe better understand just where the employer mandate fits. Let's just go back. This law was signed into effect back on March 23rd, 2010. Well, what's the significance of that? To me, the significance is here we are 4.5 years later, and many of the provisions of the Affordable Care Act have still not been implemented. And as we've discussed, the employer mandate is going to go into effect this January 1st, I think, barring any further delays or presidential delays on it, but it's only going to apply, at least initially, to companies with 100 or more full-time employees or full-time equivalent employees, and not down to the 50 that the Act overall will apply to, and that will start in 2016. It didn't take long, though, for there to be challenges to the Affordable Care Act. We went to the Supreme Court. It was argued back in March 2012. A decision was issued on June 28, 2012. And on June 29, 2012, my phone started to ring with clients starting to ask me about what is this employer mandate all about. I thought the Supreme Court was going to throw this thing out. Now you're telling me I'm going to have to comply with that. With this employer mandate. Okay, the purpose of the Affordable Care Act. The purpose of the Affordable Care Act was to reduce the number of uninsured Americans from 40 million down to some much lower number. I think originally it was thrown out that maybe we could get the number down to 10 million, knowing that it would probably be impossible to ever insure every single American or make sure that every single American has coverage. There's the old saying, you can lead the horse to water, but you can't make the horse drink. So there's always going to be a certain level. But in any event, the Affordable Care Act is designed to get that 40 million number down. The Affordable Care Act mandates more comprehensive coverage with respect to your insurance plans. For instance, preventative care now has to be covered without deductible. There can be no annual limits. One thing that I think we all enjoy, or at least I enjoy with 2 young adult children, is the new provision that says that adult children can stay on their parents' group health insurance policy to age 26. So there are some things that are very popular. It's not a single-payer system. The Affordable Care Act is trying to work within the private, and this is kind of the good and the bad. From an employer standpoint, it's bad because the Affordable Care Act and the government is asking employers to help us solve our problem of 40 million uninsured. And as a lot of my employer clients say to me is, look, I didn't go into business to provide health insurance. I went into business to make widgets or whatever I do and to make money, not to provide health insurance necessarily. And that wasn't really what I signed up for. Now, since World War II, all American businesses have pretty much gotten used to the fact that they're going to provide health insurance in conjunction with employment. But it's not a single-payer program, really. It's a program that is designed to work with private insurance and employers. Major provisions of the Affordable Care Act, and this is what I want to kind of emphasize a little bit, just so you can kind of see how the government is trying to get that 40 million uninsured number down. The first thing, the individual mandate, which I'll just very briefly go over because, again, we really want to focus today on the employer mandate. But the individual mandate is a mandate that basically says, and it went into effect this year, May 1st, it's supposed to be in effect January 1st. Of this year, 2014, but of course we had the delays with the exchanges and problems with computers and all that kind of stuff. So we're looking now at a May 1st effective date on the individual mandate. So all Americans have got to have health insurance or they're going to pay a penalty this year. So that is to encourage people to get health insurance to reduce that 40 million number. Medicaid expansion. We've increased the eligibility for Medicaid. More people at slightly higher income levels are now eligible for Medicaid. and that's something that could have been done without the Affordable Care Act. I mean, that's just an expansion of an existing program. And that's the thing about the Affordable Care Act. It has all these different components which are severable. You don't have to have them all together. And that's why there's been some discussion about the employer mandate, which is the third thing I want to mention. This is the other way that the government's trying to get that 40 million uninsured number down by making more employers provide health insurance to their employees. Whether or not the mandate's ultimately going to go into effect on January 1st, I can't tell you for sure, but I do know that as things stand right now, we're less than 3 months away from it going into effect. 6 months ago, I might have said that, I'm not really sure it's ever going to go into effect, but as of right now, it looks like it's going into effect, so I think we have to plan for it. And I think one reason it may go into effect, even though I'm not sure anybody really wants it to go into effect, I'm not even sure President Obama and the Democratic Party wants it to go into effect, but right now they're sort of in a stalemate. The Republicans basically don't want it to go into effect, but on the other hand, they'll only get rid of the employer mandate if they can get all of the Affordable Care Act thrown out. Whereas I think President Obama isn't so keen on the employer mandate because he's already delayed it twice, but that's part of the central focus of the Republicans' charges that he has abused power, that because he's just unilaterally delayed the implementation of this law, and the House of Representatives have challenged him on that, and we hear all this threat about impeachment and all that stuff, and that's the central issue, really, in terms of any charges against him of abuse of power, is the fact that he's just unilaterally delayed this employer mandate. So from his perspective, he may be hesitant to delay it again because he doesn't want to hear those charges. So again, I'm not sure anybody really wants it, but because of the political situation, I think there's a good chance it's going to go into effect and probably will go into effect this January 1st. Another piece of the Affordable Care Act is the creation of exchanges. That was the original term. Now the term is marketplaces. Everybody's heard about the issues with the marketplaces and the problems with the computers and all that, but that seems to be fairly well resolved at this point. But the purpose of the exchanges or marketplaces is to facilitate the purchase of health insurance. So that individuals can go to these exchanges or marketplaces and type in their information and receive health insurance or get quotes for health insurance from private insurers. And that's the key point. It's really for private insurers. Now, you can also sign up for expanded Medicaid through the exchanges, and to the extent you're hearing about a lot of additional people being covered under the exchanges, frankly, it's through the Medicaid program. And then just, the last piece of it is just more coverage mandates for health insurance. Health insurance has to cover more things. So that's kind of a broad overview of the Affordable Care Act. Then, as I mentioned before, the individual mandate, I'm not going to spend much time on it. It's basically a requirement that every American citizen have minimum essential coverage, which is actually a fairly low standard, or pay a penalty or some type of tax if you don't. The coverage options to meet this are varied. You can do it through Medicare, Medicaid, employer-sponsored coverage, which probably for our purposes is significant. I think the one thing that I would want to mention about the individual mandate and how it ties into employers and employer issues is the fact that the individual mandate may increase participation in your health insurance programs. I don't know what you individually, you may be starting to have some experience with this, but I know one of my clients was very concerned a year or so ago that because of the individual mandate, a large number of his employees who had previously waived insurance, even though he provided a comprehensive health insurance plan with a generous employer contribution, because he had a lot of low-paid employees, a lot of people waived coverage. And his concern was that by having this individual mandate, all of a sudden a bunch of these individuals who have always previously waived coverage would now sign up for coverage, which would cost him a lot of money because, he, as I said, he does provide a generous employer contribution for the health insurance, and employees previously had opted out. So and he was waking up in the middle of the night worried that he was suddenly going to have $400,000 of additional cost a year because he was going to have all these employees sign up. And I don't know exactly how that is shaking out. But that's something to watch for. Just real briefly, the individual mandate penalties for 2014, $95 per adult, $285 household max, or 1%. But it's the greater of. And there's been a lot of focus on this number. Well, the individual mandate, who cares? It's only $95. Well, that's not quite the case. I mean, it's $95 if you make $9,500 or less a year. But if you make $20,000 a year, then 1% is $200, and 30,000, 1% is $300. So it does go up a little bit. Not that somebody's necessarily going to sign up for health insurance over $200 or $300 because it's still probably cheaper to go without. But the penalty is a little more significant. But it does go up each year. So that's something to watch for. There's also a bunch of exemptions to the individual mandate penalty: financial hardship, religious objections, American Indians. It's a whole laundry list. You can go without coverage for less than 3 months and you're okay. So we'll see how that all shakes out. Through the exchange, there are a lot of ways to get additional or subsidies, either, as I mentioned, through Medicaid or premium tax credits. At this point, does anybody have any questions regarding the individual mandate? Yes, sir.
Does the individual mandate apply to every person, children as well as adults?
Yes. Yes, it does. Children pay a lesser penalty. It's, let's see, half. Penalty for individual is 1/2 the adult penalty. So yes, it does apply to children. Yes, ma'am.
Andy, will we be able to have slots for the participants in the room? Will we be able to get your presentation?
Yes, you can just email me and I'll send you a copy of this PowerPoint presentation. My email address will be on the last slide, but if you want to just write it down, it's ajacobs@stites.com. ajacobs@stites.com. Just shoot me an email and I'll be happy to send a return back with a copy of this PowerPoint. Thank you for saying that, because I was going to say it, but I forgot to say it. So, okay. With that, we will now go on to the employer mandate, or it's the employer shared responsibility tax, aka the employer mandate. As Jerry was saying a little earlier, there's two real parts to the employer mandate. The first part is in section 4980HA of the Internal Revenue Code. And what it says is, this is the portion that says you have to offer your employees minimum essential coverage. Again, a fairly low threshold, minimum essential coverage. You have to offer at least 95% minimum essential coverage to at least 95% of your eligible employees, i.e. full-time employees, those who may work over 30 hours a week. Now, there is some transition relief for 2015. If you're one of these employers that's going to be subject to the employer mandate in 2015 because you have over 100 full-time employees, then the threshold is only 70%. So, it's a much lower standard. But you have to offer coverage to a certain percentage of your workforce in order to avoid this penalty. If you do not meet these thresholds, the 95% or the 70% for 2015, then you will be assessed a penalty for every month that you are not in compliance. And that penalty basically equals, for the month, 1/12 of $2,000 minus 30 allocable employees. And if you're a member of a controlled group, that 30 will be allocated amongst your controlled group of related employers. And for 2015, that is 80. So what does all this mean? Here's what it means. Let's say you have 60 full-time employees, and you decide you're not going to offer health insurance to your employees. Since you only have 60 full-time employees, you get to subtract the first 30 in calculating this penalty. So you pay a penalty just on half your workforce, or 30 employees, and you pay a penalty of $2,000 a year for each employee, or $60,000. Divided that down on a monthly basis, it's $5,000. So it is entirely possible that some employers may say, look, I'd rather pay a $60,000 penalty a year and I'm out of the health insurance business. How many employers will do that, I don't know. I suspect when it's all said and done, most employers will not do that. There will be very few employers who will actually go to that sort of measure. But with that said, certainly there'll be some employers who will do it. I mean, it's a big country. There's a lot of employers out there. Somebody will probably do it, but probably not a huge number. But that's the penalty, and it also presumes that at least one of your full-time employees goes to the marketplace and receives a tax credit, a premium tax credit for the insurance purchased, which is a pretty low threshold. So anyway, that's the tax if you do not offer coverage to any of your employees. You just say, look, I'm out of it, or if you don't offer coverage to at least 70%. Okay? Then the next tax is under 4980HB of the Internal Revenue Code. And this is the tax that says, okay, even if you offer coverage to all of you, or to a certain percentage of your employees, to 95% of your employees, if certain employees fall through the cracks or not offered coverage, then we're still going to assess you a penalty if that employee goes to an exchange and receives a tax credit. And the way you can avoid the penalty, the only way you can avoid the penalty, any penalty here, is by offering your employees coverage that is affordable. That means you're going to basically have to provide some type of employer contribution, because the employee, for single employee coverage only, cannot be required to pay more than 9.5% of their income. The term in the statute is household income, but I think really from a safe harbor standpoint, you'll just use your W-2, because how are you going to know what somebody's household income is? You don't know what their spouse does, or nor do you know what other outside income they have. So as a safe harbor, you can use a W-2 income, but to know this. But so it has to be affordable, and it also has to meet a 60% minimum value standard. Now, this 60% minimum value standard is higher than the minimum essential coverage standard that we mentioned in the previous penalty, the overall coverage penalty. But that's the but most plans offered in America today, and even before the Affordable Care Act, would have met this 60% minimum value standard. But what it basically is actuarially your plan has to cover 60% of what somebody's potential health care costs could be. And again, I think it's a fairly low standard, and most of your insurance agents can help you with that. But if you don't meet this standard, if you don't offer affordable coverage and the coverage that meets the minimum value standard, and you have an employee go to the marketplace or exchange and receive a premium tax credit, then for every month that occurs, you will be penalized 1/12 of $3,000 per employee, or $250 a month per employee that actually receives the credit. Not all your employees, just the employees who receive the credit. But it is capped. But in no event under this penalty will you be required to pay more than you'd have to pay under the first penalty for failure to meet the minimum coverage standards, which is the $2,000 a year, 1/12 of $2,000 on a monthly basis. So those are the two coverage tests. Yes?
How would you know that an employee received the tax credit?
You'll find out from the federal government will let you know, yes. At the end this will all be assessed and collected at the end of the year, yes. Yeah. Well, you raise another good point, is the enforcement of all this, and we'll see how that goes. Okay? So those are the...
Is it possible that you would get, it's possible you'd have both taxes and up to the maximum whatever they don't...
Well, as a practical matter, you'd really only have the first tax, because that's the cap, and so that's the one you'd end up paying for not offering coverage. Okay? Okay, so those are the two levels of tax. Okay, now, how do you know whether the employer mandate even applies to you? Well, the one thing we know is you have to be an applicable large employer. Are you an applicable large employer? Well, the threshold is, do you have 50 or more full-time employees or full-time equivalent employees in the preceding tax year, or the preceding calendar year, I should say. So in 2015, the focus is on 2014 and what your workforce looks like on an average business day in 2014. There's also special transition relief. There's lots of special transition relief. For 2015, the employer may select any 6-month period in 2014 as the determination period. So you don't have to use the 12-month period. You can selectively pick a 6-month period to determine whether or not you're going to be subject to the test. Or to the standard for 2015. And remember, for 2015, we'll cover it under some more transition relief. You have to have at least 100 full-time employees to be subject to these employer mandate provisions for 2015. Okay. Full-time employee is an employee that is employed on average at least 30 hours per week or more. Then here's the tricky part, full-time equivalent employees. Let's say, for instance, you have 40 full-time employees, you just do, and they work 40 hours a week or whatever, so you have 40, okay? But you also have 20 part-time employees, and they each work on average 15 hours a week. Basically, those part-time employees, only for this purpose of seeing whether or not you're subject to the employer mandate provisions in the first instance, but only for this purpose, those part-time employees will be aggregated. So if you have 2 employees that work 15 hours a week, then they add up to 1 employee that works 30 hours a week, and therefore that's 1 additional full-time person. So if you had 20 part-time employees working 15 hours a week, they constitute 10 full-time employees for purposes of this this eligibility criteria, and so you would add 10 to the 40 full-time employees you have, and now you're subject to the Affordable Care Act and the employer mandate provisions. Okay, you only count, and the test is a little more complicated than that because you use 120 hours. You add up all your part-time hours and divide by 120. Common law employer test to determine if the employee or if somebody's an employee or independent contractor. So the common law employer, so that's one of the questions is, well, how do I know whether that individual is an employee or is it an independent contractor? I think probably the easiest way to know, or probably from a practical standpoint, it's going to be W-2 compensation. You're going to be counting W-2s. In theory, at least, the IRS could come in and challenge some independent contractor classifications, which at some point in time may occur. But the basic definition between, or the basic distinction between an employee and independent contractor is an employee is someone, not only do you have the ability to control the end result, but you also have the ability to control the means by which that individual reaches that end result. For instance, if you hire a painter to paint your house and you say, well, for $2,000, he says, I'll paint your house for $2,000, you don't tell that painter what brushes to use, what brush strokes to use, or his equipment or his techniques, how to do the job. You only judge the end result, and if at the end of the day your house looks good, you pay him the $2,000 and you move on. Well, that's an independent contractor. But if you, on the other hand, had the ability to tell him in great detail, how to do it, and not that it doesn't sometimes occur that way, but a lot of the technique and when to do it and all of that, then that's then you might be an employee. Not that I think there's any risk ever that a painter that comes for 1 week to paint your house is ever going to be classified as an employee. Usually this comes up when you have long-term individuals who have been employed for long periods of time as quote, as an independent contractor, and usually it only comes up when you have about 5,000 of them, like say Microsoft. Realistically, if it's going to attract the IRS's attention if you're doing it on a large scale. Seasonal employees, basically the rule is here that seasonal employees are not going to make you subject to the employer mandate provisions. If seasonal employees put you over the 50 full-time employee limit, we'll give you a break on that, is what the government is saying. And generally, only employees who are in and work performed in the United States are counted. So, if you have overseas operations, they're not generally going to be counted as part of the 50 employee standard. Okay, controlled groups. Okay, now we know it's 50 employees, 100 for this year. Controlled groups. This is a term that many of you may be familiar with in the retirement plan context. We go to our old favorite provisions, 414B, C, M, and O of the Internal Revenue Code, and we look to see all the different members of the controlled group. So if you have, if several you have a parent-subsidiary, they're aggregated together. If you have brother-sister corporations, say the same individual owns 3 different companies, could be 3 separate companies, company A, B, and C, and if one individual owns all 3 of those companies, or for that matter, if the same 5 or fewer individuals own 80% or more of all 3 of those companies, then they are aggregated together. And so if each one had 20, one had 15, and the other had 20, that's 55, so you'd be subject to the employer mandate. Now, what's important with control groups is you use the control group test to determine whether or not you are subject to the employer mandate. You use it for purposes of this 50 employee, or for this year, 2015, the 100 employee threshold. But once you start actually getting into the compliance and calculating the penalties and look at actual compliance, each company stands on its own. So in terms of enforcing these provisions, each one of those members basically stands on its own and would pay separate penalties, but at least for purposes of determining whether or not you're subject to the Affordable Care Act, the employer mandate provision that is, you would aggregate. And that's why, just to run back really quick, back here, I say, this is one of the first slides, this is the minimum essential coverage test. Remember I said minus 30, so if you had 60 employees, you would subtract 30 and only pay the penalty on 30. That 30 is allocated ratably among all members of the controlled group. So if you had different members, you would allocate, I think it's proportional based on your number of employees in each group. So that number would get broken down. So if you were a member of a three-company controlled group, you might only be allocated 10 of those employees. And the other 2 members of the control group might pass the test and not have any penalty, but you would only get a reduction of 10 employees. All real simple, right, and straightforward. So, okay, those are and the controlled group rules, just real briefly, 80% common ownership test. It could be a parent-subsidiary relationship, or it could be a brother-sister relationship. And the brother-sister is, again, a situation where the same 5 or fewer individuals own 80% or more of each company. That's the way that's done. Affiliated service group, I'm not going to spend a lot of time talking about affiliated service groups, but that's another way that employers can be treated as part of the same controlled group if they're members of an affiliated service group. Even if there's not a huge amount of common ownership, if there's sort of and this really applies in the doctor context. I mean, that's really when affiliated service groups come up, is when doctors, in the pension world, there's a lot of things that are focused on doctors over the years. They're always worried about doctors trying to beat the system. And it's basically, it applies, when the doctors would try to sub out all their staff work to another company and just have their own corporation, the PSC, and just have a retirement plan for themselves. And the IRS said, well, you can't do that. And it's these complicated affiliated service group rules. So another set of rules that could create aggregation of employers. What if you're a new employer in 2015? The rule is this. the first question is, are you reasonably expected to employ, and actually I shouldn't say 2015, it's really 2016 if I'm using the 50 employee, but really for 2015, let's say it really should say 100, again, some more transition relief. But for 2015, if you reasonably expect to have 100 or more full-time employees and full-time equivalents, and in fact you do employ 100 or more full-time employees and full-time equivalents during the year, then you will be subject to the employer mandate provisions in 2015. But it's a two-part test. You have to reasonably expect, whatever that means, reasonably expected to employ 50 or more. Now, I didn't, I certainly didn't expect. I got 500 employees, but no, I didn't expect to have them. And I had 500 employees on the first day that we opened our doors. But anyway, that's I think under those circumstances you'd have a hard time arguing that you didn't reasonably expect to have the threshold. Okay, transition relief. This is the big. Yes, sir.
Quick question. If I have 20 employees,
yes.
I utilize a service like Century 2,
yeah.
PEO, which has much more than 20 employees.
Mm-hmm.
My understanding was that I would be subject to that because my employees are also employees of Century 2. Is that correct?
Well, I think it comes down to who's the common law employer. And I'm not sure I know enough about your all's relationship with Century 2. I'd be happy to talk to you later about that. I'm not sure I know enough to comment on that and the co-employee, that relationship.
Later question. So the control group.
Yes.
The penalties are potentially based on how much coverage you're offering are based on the aggregate of what's offered by that controlled group, not what if the individual groups offer different things to their employees. One is totally in compliance and one is totally out of compliance, but they have more employees. Does that then potentially apply a penalty to the member of that group?
No. The penalties are assessed company by company. Compliance is measured company by company. The only time you aggregate is to determine whether or not you're even subject to the employer mandate. But once you're subject to the employer mandate, then compliance is assessed on a company-by-company basis. Yes?
And you just addressed the comment earlier. The association actually was of professional employer organizations, which Century 2 is a part of, was successful in getting a colloquy attached to the regulation that was passed, saying that the counts for all of this does go down to the worksite employee.
Okay. So you're saying so for purposes of determining whether or not you're subject to the employer mandate, you focus just on the individual employer and whether the individual employer has 50 or more?
For the mandates, for the rules, for the counts, it's the same on the tax credit side. The tax credits for the employer will go back to the worksite employer count.
Okay.
Employer, as well as the penalties for mandates.
Okay. Okay. Thank you.
Andy,
yes.
Let me ask something. If you'll go back one slide, I mean, for the new employer, I mean, how does this work as far as, all right, January 1st, 2015, I'm a new employer, and I reasonably expect, to hire or have employed 100 or more full-time equivalents. But the second part of that says, and then they do, in fact, employ.
Yes. Yeah, it's two-part, yeah.
It's like the first part of it is what do you expect to do. The second part of it is what you actually do. So how do you know on January 1st if you were actually going to reach that expectation?
Well, you don't necessarily. I mean, I think on January 1st, if you reasonably think that you're going to reach or be at 100 employees and subject to it, then I think you'd better go ahead and get the health insurance lined up. That's what I would say. But you're right. And then
at the end of the year, you may look back and say, "Well, I didn't."
Well, yeah, I had to lay off a bunch of people or whatever. So, yeah, it's one of those catch-22s. I think to be safe, though, you'd want to go out and get the coverage. Okay. A big part of the transition relief and what we probably know about the most, or maybe it's the most germane at this point in time, is the relief that applies here for 2015, because the employer mandate provisions are not going to be subject, or are not going to apply to employers with 50 to 99 full-time or full-time equivalent employees. 2016 is when those companies are going to have to get into compliance. But for 2015, it's only going to apply to full-time, to companies with 100 full-time employees. Again, you use 2014 as your determination period, so you're looking back, and you can use any 6 months, part of the transition relief. And then these are sort of some anti-abuse provisions that they've tied onto this. What the government is saying, or the IRS really is saying in this case, is, look, we're not going to assess a penalty against you in 2015 unless you have over 100 full-time employees. But you can't have reduced your workforce between February 9th, when we issued these regulations, and December 31st, 2014, and expect to get out of this. We're not going to let you go from 110 employees and just go ahead and lay off 15 employees so you get under the 100 employee threshold. If you do that, you better have some bona fide business reasons for doing it, and not just trying to evade coverage. You also can't eliminate or materially reduce your health coverage. And so those are kind of like some anti-abuse provisions. They just want to make sure that nobody games the system in trying to get under the limit, so that the employer mandate's not applicable for 2015. Go ahead, Pat. I'll start with Pat, and then I'll pass.
I was just talking about gaming the system. If an employer is not under the mandate,
mm-hmm.
and they don't have to provide health insurance, but maybe they have in the past.
Yeah.
And so they're basically saying, okay, employees, we're not going to provide coverage. You're going to have to fend for yourself because you now have the personal mandate.
Yeah.
Correct?
Yes.
Is there any prohibition by the employer paying that tax for the individual?
No,
Okay.
I don't think so. I mean, it would be. It'd probably have to be grossed up.
Sure.
It'd be on an after-tax basis. I don't think there's
not a prohibited language anywhere.
Not that I might have to think about it, but no, I don't think so. No, because I don't think there's any reason.
I know business owners will game the system if it's not.
Yeah.
Gaming the system is really not the right term. It's using the law to their advantage if
yeah.
they can.
Or trying to survive might be another way of putting it.
So, if an employer says, I'm not going to provide it, and by the way, I'll pay your tax personally, I'll gross it up. Yeah. That would obviously be.
Yeah, and this is for employers under the 50.
Under the 50.
Yeah, who otherwise are not subject to the employer mandate. They would pay the tax. I don't know if many will do that, but that'd be potentially possible.
Is there any law that prohibits them to?
No, as long as it's after tax. The employer you can always bonus somebody. It's taxable income for whatever purpose, and you don't necessarily have to even advertise specifically what it's for. Yes, ma'am.
I was just asking on the 9.5% of an income. Is
Yeah.
that on a gross or a?
I think it's adjusted. I think it's W-2 income. It's W-2.
So is it gross W-2?
W-2.
It's W-2, yes. Well, W-2 is gross by definition. And see, that's the thing with household income. The statute actually says household income, but that gets into the question, I think it's adjustable income. It's after deductions. Well, so how are you going to know what somebody's household income? If you're the employer, how are you really going to know what your employee's household income? Because you got deductions and all these other complications. But W-2 is, and there's some other safe harbors that you can use as well. I just threw out the W-2 one. But that's probably what most employers are going to use to determine the 9.5%. I think you can also use the federal poverty level as well, as long as it's not more than 9.5% of that. Okay. Okay. Well, this is kind of a little bit of review. Final regulations were just issued in February of 2014. We know we've beaten this to death. Employers with non-calendar year plans. This is important. This is another big transition relief piece. For the most part, employers with non-calendar year plans will not be subject to enforcement until the beginning of their 2015 plan year. And what the IRS is saying here is we realize that a lot of employers have plan years that are not calendar years. They have fiscal years. They might start in March. They might start in April. October, whatever the case might be. And what the IRS is saying is that in those cases, if you meet certain criteria, and the criteria is pretty broad, so it's pretty general, enforcement does not begin until the beginning of your plan year. So you have to be in compliance at the beginning of your plan year if you have a non-calendar year plan. You don't necessarily have to be in compliance on January 1st of 2015. And then I'll talk about this in a minute, the reporting requirements. And I will not go over this slide. This is a couple slides that I'm not going to spend much time on. I could spend literally half a day just talking about this. This is the look-back periods. This is not used for purposes of determining whether you're subject to the employer mandate. This is, employers might use the look-back periods to determine whether or not their individual employees are full-time or not full-time, because a lot of employers have variable hour employees, people who work right on that 30-hour threshold. Some months they may average 28 hours. Other months they may average 32 hours. And, how do you know? Or, generally an employee may work just 20 or 25 hours a month, but maybe in certain months they might spike up and work 40 hours a week for that month. So how do you have some consistency? So what the IRS has come up with are these look-back periods, standard measurement periods, a stability period. And what this is saying is, well, let me just give you the best example. I think the best way of explaining it is with an example. Let's say, for instance, you had an employer with a March 1st plan year. They could have a stability period of the previous calendar year's 12-month period. So let's say it's March 1st, 2016 is the beginning of your plan year. You could have a stability period of all of 2015. So you look during 2015 for that 12-month period whether or not a given employee averaged 30 or more hours per week. If they did average 30 or more hours a week during that stability or that standard measurement period the previous year, then you can assume that they will have worked 30 or more hours a week for the next year during your plan year, that March 1st, 2016 plan year. If they didn't work 30 hours on average in that previous standard measurement period, then you are safe in not offering coverage to those individuals during that next plan year that starts March 1st, 2016. And remember, the standard measurement period was January 1st to December 31st of 2015. Then you had a 2-month administrative period which you're allowed, and that can be up to 90 days to determine how many hours people worked back in the previous measurement period. So it's all quite complicated. I could spend literally half a day going through all these rules on it, but suffice it to say, if you have a lot of variable employees in your workforce, and by variable I mean employees who are kind of right on that threshold of 30 hours, sometimes they are, sometimes they're not, and you want to have some certainty, because this penalty is calculated on a monthly basis. It's every month, and sometimes you're not going to know whether somebody's going to be over 30 hours for the month. You may not know till the last week of the month. So to give employers some predictability, you can kind of look at these look-back. You can use these look-back periods, this look-back methodology, and look at a period of time previously and whether they were full-time or not, and then apply that going forward. So again, it's pretty complicated, but and we won't spend a lot of time on it here today. Reporting. Good news is reporting doesn't start until for the 2015 year. All the reporting is done in 2016. It's kind of like W-2s. You'll issue your W-2s in January of 2016 for 2015. And so the reporting that you'll be required to do if you're subject to the employer mandate doesn't occur for the first time. It will occur in January and February of 2016 for the 2015 plan year. The IRS would love you to go ahead and just voluntarily report here in January of 2015 for 2014, but it's not required. I think one thing, though, that is important to note here is that even for employers with 50 or more but under 100 full-time employees, so even if you're exempt from the employer mandate for 2015, because you're in that 50 to 99 employee bubble, you still need to report for 2015 if for no other reason, and you'll do that in January of 2016, if for no other reason just to claim your exemption. Code Section 6056, that's Internal Revenue Code Section 6056, requires this reporting, and this is for purposes of enforcing the employer mandate. 6055 requires self-insured plans that the sponsor, which is the employer of a self-insured plan, or the insurance companies for fully insured plans, will have to report for purposes of enforcement of the individual mandate. How will it be enforced? How will you be assessed a penalty? It'll all be done at the beginning of the following year, it'll be after employees file their individual tax returns. You'll receive, if you're the employer, you could receive an assessment. You'll have an opportunity to defend yourself and argue why you shouldn't. And how this is all going to play out, frankly, I don't know. Maybe the government. I'm not sure the government knows at this point how they're going to, get it all worked out. So
to
yes,
make
Pat.
sure, so if you have somebody that's not going to be subject to any kind of penalty next year, but they don't report it, there still could be a fine of some sort. It's not been determined what it would be, but if they're in the 50 to 99, so they don't really have to provide it next year. They're
required to report even
if they fail to report, but
yeah.
there would be no penalty because they're exempt for the year. Is there a
they're
for not reporting?
Yeah, they're probably.
Don't know what that is.
Well, I'm not sure. I'm not sure exactly what the penalty is. It'd probably be something similar to W-2s. I mean,
late filing. Some
kind of late filing fee of some sort. I'm not sure exactly what it might be. Okay, that's the employer mandate. That concludes my presentation on the employer mandate. I want to go on to health plan design issues. Does anybody, before I go on, does anybody have any employer mandate related questions? Okay, well, the rest of the material I can probably cover fairly quickly. These are, again, health plan design issues and how health plan design has been impacted by the Affordable Care Act. Employer payment plans are no longer permitted as a result of the Affordable Care Act. These type of plans have basically been in existence since the 1960s. An IRS revenue ruling in the 1960s established these plans. And what an employer payment plan is where the employer will reimburse the employee or pay the insurance company directly on behalf of the employee for individual health insurance coverage on a pre-tax basis. So this is coverage that's not offered by the employer. The employer just says to the employee, I will pay your individual coverage on it. And they used to be able to do it on a pre-tax basis. You can no longer do it on a pre-tax basis. You could still do it, but it's going to be after-tax income to the employee. So it can only be done on an after-tax basis. So these are plans that have been popular with a lot of employers in the past for the last 40 years, but no longer are applicable or permitted. And the rationale for it, and I'll let you decide what you think about this rationale, is that an employer payment plan is like a group health plan. Even though it's only paying for the premiums, it itself is treated as an isolated group health plan, and the government is saying because it is a group health plan, it has to meet the various different market reform requirements and mandated provisions, such as you cannot have an annual limit, an annual limit on how much can be paid, or you've got to cover preventative care. Well, this is a plan that only pays premiums, so in theory it doesn't offer any of those types of coverages. So the IRS is saying you can no longer do this. You can no longer have one of these employer payment plans. And here's the real kicker, because you might say, well, I can understand. I mean, you can say, well, the IRS they don't want to encourage employers to do this, and I'm not really sure why. But here's the real kicker. Whether it will be enforced or not, I don't know, but non-compliance can result in severe penalties of up to $100 per day per employee. That's I think the cap a year is $36,000 per employee. So in theory, at least, if you had one of these plans, the penalties are pretty severe. So stay away from employer payment plans. Don't try to pay for your employees' individual coverage premiums on a pre-tax dollar basis, but you can do it on an after-tax dollar basis. Health flexible spending accounts. The Affordable Care Act has changed health flexible spending accounts in a couple ways. First of all, the new limit for employee contributions is $2,500. In the way most employers set up their health flexible spending accounts, this is really the most significant thing about the Affordable Care Act, because it used to be that this was an unlimited number. Employees could defer a lot more than $2,500. Now, most employers didn't want to have limits much above $2,500 because they were concerned about the risk of an employee at the beginning of the year using the full limit, $3,000 of coverage, and getting reimbursed $3,000 in the first 2 months of the year, and then terminate employment, and the employer never has a chance to recover those premiums from the employee. So most employers always kept the contribution limit fairly low anyway, but now the IRS is saying it has to be limited to no more than $2,500. And most people would say, well, why should the Affordable Care Act care that much about flexible spending accounts? Because they're really kind of good things. I mean, nobody's really depending on a flexible spending account as their main form of health insurance. It's just to help pay for some additional things. But the IRS is saying that, well, a flexible spending account is its own separate group health plan that will not meet all the mandated requirements under the Affordable Care Act as to what a group health plan has to cover. So the only way a health flexible spending account can now exist is it has to be an accepted benefit. That is, it needs to meet this definition to be accepted from HIPAA or, for that matter, the Affordable Care Act. Now, as a practical matter, most health FSAs have always met this, but the employer has to offer other group health plan coverage to be accepted. And then second of all, the maximum payment is no greater than 2 times participant's salary reduction amount, or if greater, $500 plus the amount of salary reduction. Most employers either do not make an employer contribution or make a contribution that is low enough that these maximums are not going to be in jeopardy. But in any event, health flexible spending accounts, you just have to monitor them. They're still basically good. 99% of the ones that are out there are, meet the requirements probably and are okay. But if you have one that doesn't meet these requirements to be an accepted benefit, then you need to be looking at that. And actually, you need to have that changed by January 1st of this year. But in any event, sometimes better late than never. Wellness programs. The Affordable Care Act doesn't have a whole lot to say about wellness programs other than the fact that it's generally encouraging wellness programs. Wellness programs are a little bit dicey in the sense that you have to meet various different non-discrimination requirements. The big one is HIPAA. You cannot discriminate based on a health-related factor. You also have EEOC type of things you have to worry about, like disabilities, Americans with Disabilities Act, and things of that nature with wellness plans. But a wellness plan can basically be designed, if you meet certain criteria, to comply with HIPAA, and there's basically 4 criteria that you have to meet. I think the long and short of it is the Affordable Care Act helps make it a little bit easier to meet those criteria to be accepted from HIPAA. And in particular, the Affordable Care Act takes an anti-smoking approach, and so they allow greater incentives to be used for programs designed to prevent or reduce tobacco use. So I think with wellness programs, I mean, they're definitely a wave of the future. I see them becoming more and more popular, and I think the federal government wants to encourage wellness programs, even though, especially in the EEOC context of disabilities, age discrimination, those types of things, there's still some fuzziness in terms of what the law is, but at least the Affordable Care Act is, I think, trying to encourage wellness programs. Health reimbursement arrangements, these are HRAs. I don't know how many of you all maintain HRAs. Again, usually these are plans that are sort of ancillary plans. They're designed to be additional coverage. They're not designed to be the person's primary coverage for health insurance from the employer. It's an account kind of like a flexible spending account, except that it's fully funded by the employer, and monies in an HRA can carry over from year to year. And what the Affordable Care Act says is HRAs do not meet the requirements of our various market reforms and will not be treated as Affordable Care Act compliant unless the HRA is integrated with other group health plan coverage that then satisfies the market reforms. Then the HRA is permissible. So the HRA can piggyback onto another group health plan, and if it's integrated with that, it's okay. I won't go into a lot of detail on that, but suffice it to say, if you have an HRA plan, and does anybody have an HRA plan here? Okay. You just need to make sure that it meets these standards, that it is integrated with your group health plan. Since you actually have one, I'll just briefly go through it. And there's also an alternative standard, but an HRA will be integrated with a group health plan if the employer offers a group health plan that meets the minimum value test, so the employer has to offer a decent health insurance plan. The employee is actually enrolled in a group health plan that meets the minimum value test, and it just has to be a group health plan, even if the plan is of another employer. So if you're covered by your spouse's plan, if your employee is covered by the spouse's plan, that's okay. The HRA is available only to employees who are enrolled in a non-HRA group health coverage. So, the HRA requires as an eligibility provision that you be enrolled in some other group coverage, and then the employee is permitted to permanently opt out of and waive future HRA reimbursements at least annually. So the employee has the ability to opt out. So you have to meet those requirements. There is an alternative standard as well, but if you have an HRA, just make sure it's integrated with your group health plan so that it is compliant. Otherwise, you could be subject to the $100 a day per employee penalty that we were talking about earlier. So you want to just make sure that your HRA is compliant. Health savings accounts, these are things that have become immensely popular in recent years, probably over the last 10 years or so. The Affordable Care Act, I don't think really likes necessarily health savings accounts, but because I think in Washington there's some perception that health savings accounts are mainly for higher income people, but in any event, though, it did not try to eliminate health savings accounts, but it does. Let's see. You can't use your HSA funds to buy over-the-counter drugs without a prescription. That's a new Affordable Care Act rule, and it subjects any kind of non-medical withdrawals to a 20% penalty, up from a 10% penalty. So it's a little bit of greater penalty if you use your HSA for non-healthcare purposes. Okay. And of course, the great thing about HSAs is, at age 65, I think it's age 65, at some point you can use it as retirement savings. It kicks in, and you don't necessarily have to use it just for health purposes. But I think that's age 65 before you can use it for non-health related purposes. COBRA, just make sure you update your COBRA notices. Then, you can go to the Department of Labor website. They have new model notices, and the notices will have language in them advising employees about the marketplace exchanges because, and this is really a good thing. From an employer standpoint, you want to encourage this, because what you can do is basically say, look, before you sign up for COBRA, you probably might want to explore your options under the marketplace. And most employers really don't want COBRA participants anyway, because COBRA participants have a history of adverse selection. Typically the people who sign up for COBRA are sick. So you can kind of tell them in your notice, say, look, you might want to also explore a marketplace and exchange, and there's an exception to the normal enrollment periods under the marketplace. There's a 60-day special enrollment period after you terminate employment in which you can go to a marketplace or an exchange and sign up for coverage and not necessarily have to obtain COBRA coverage. So that's something to note. Non-discrimination rules. We're talking about this act having been passed back in March of 2010, and here we are 4.5 years later. Well, this is really kind of the epitome of the delays. The non-discrimination rules, were supposed to go into effect so long ago, to be quite honest with you, I can't even remember what year. I think they were supposed to go into effect in 2011, but again, it's been so long ago, I think I've even lost track, but certainly no later than 2012. And what these non-discrimination rules are is this. Historically, self-insured plans have always been subject to non-discrimination rules under Section 105H of the Internal Revenue Code. So if you had a self-insured plan, you also always had to be careful not to discriminate in favor of your highly compensated employees. And for that purpose, highly compensated is defined as anybody in the top 25% paid of your workforce, as opposed to under the retirement plan rules, which most people are familiar with, it's more like 115,000, I think, to be highly compensated. So theoretically, you could have people going way down below that $115,000 threshold who could be treated as highly compensated. So a self-insured plan could not discriminate in terms of eligibility or benefits in favor of the highly compensated. So you couldn't have any special deals for the executives, basically. The fully insured plans, though, have never been subject to non-discrimination. Back in the late 80s, there was a thing called Section 89 that was enacted by Congress that was going to provide non-discrimination rules for fully insured plans, but there was such an uproar that it was repealed before it ever went into effect. But now the Affordable Care Act is saying we're going to apply rules similar to those rules that are applicable under 105H, the self-insured plans. We're going to apply such rules to fully insured plans. The problem is the IRS, after 35, 40 years, still is not really sure what the 105H rules are. The regulations are these kind of crinkled old, in my book, they're these crinkled old yellow regulations that have been around forever. They're hard to even understand what they're even saying. And so basically what the IRS has now said is even though this thing was supposed to go into effect, it was okay. It's supposed to be effective for plan years beginning on or after September 23rd, 2010. Well, the IRS has basically said, look, until we figure out what we think the rules should be or what the rules are, you don't have to worry about it. So, and here it is now. I mean, at that time, I thought, well, I guess we'll have regulations out within a year. Well, here we are. It's 4 years later. We still don't have regulations. If the regulations come out, there'll be a certain lag time. The IRS has already said if we issue regulations, you'll have some time to prepare. So I think you can probably safely assume that these rules are not going to be applicable for 2015, because even if the regulations came out today, I guess they could come out today and give you 90 days, which would be awfully short notice. I think they'll provide at least 6 months notice. So we're probably good for another year with no non-discrimination rules applicable to fully insured plans, not self-insured plans, but fully insured plans. Okay, exchanges. Just want to briefly talk about the infamous exchanges or marketplaces. Again, these are places that are designed to facilitate coverage, that individuals can go to an exchange and obtain coverage in the private health insurance market. It's designed to make it easier to obtain coverage, so you only have to go one place. You don't necessarily, if you're an individual looking for coverage, you don't have to call 10 different insurance agents trying to find coverage. You just go to these exchanges. So that's sort of what that's the purpose of that. And that, again, that's on the individual market. And you can also apply for Medicaid and CHIP, which is children's coverage for children, through the exchange. You can get subsidies up to 400% of the federal poverty level, which for a family of four is quite high. It's over $90,000. The federal 400% of the federal poverty level, because I think for a family of four, in fact, I can tell you, and these are the states, that have created their own exchanges. And I'll go back to I just wanted to jump ahead to a slide, but these are the states in dark blue that have created their own exchanges. Of course, states that have not created their own exchanges and rely on the federal exchange, and obviously Tennessee being one of those states. I think for an individual, the federal poverty level is around $11,000 a year. So theoretically, somebody who's making up to $44,000 a year, give or take, could go to an exchange and be eligible for some type of subsidy. If you're a family of 4, I believe the federal poverty level is around $22,000 or $23,000, or maybe it's $24,000 a year now. And so 400% of that would be up over $90,000. So the point simply being is just because you have a fairly substantial income doesn't mean that you wouldn't be eligible for any type of subsidy. Now, with that said, it is my understanding, and my own playing around with this on some websites, that if you have a, unless you're down close to the bottom in terms of income, that the amount of subsidies really taper off greatly. I have a daughter who graduated from college about a year ago, and I kind of typed in her numbers to see, and I think her subsidy was going to be like $20 a month. So and she doesn't have a great job necessarily, but it's so if you have a decent job at all, the subsidy is going to be pretty small. But nevertheless, there are a lot of subsidies available. And, of course, this has been a highly charged, highly political issue on the exchanges. And, premiums or tax credits are available, and there are also cost-sharing subsidies.